Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting to the dispatch of business. God save the state and this honorable court.
Good morning. Excuse me. Our first case is Langley versus Autocraft, Inc. et al. We will hear from the appellant.
Mr. Chief Justice, may it please the court, at this time I'd like to reserve 5 minutes for rebuttal. My name is Kevin Rust. I represent Josh Langley. With me is Craig Allman today, an associate at my firm. Today, I suspect from the defendants, the appellee, we are going to hear a lot of arguments about what this court meant when it authored the Canteen decision. And I think the court meant exactly what it said, that an otherwise illusory contract may be remedied because a limitation on the promisor's freedom of choice may be supplied by law, which is the duty of good faith and fair dealing. So, turning to the facts at this case, on page 10 of the record, this case arises out of a single-page employment contract. It's titled Josh Langley's Autocraft contract. I'll clip through some of the material terms here. Again, not a terribly lengthy document, but Josh is going to get paid $125,000 per year on a per-week basis. They set out the per-week basis of $2,400 a week, approximately. The paycheck will be bi-weekly. There'll be no punching of a time clock, 40 to 42 hours per week, 2% cost of living raise per year, and a 5% Christmas bonus at the end of each year. Autocraft testified during its Rule 30b-6 deposition that it complied with these terms. There's no question about it. And at the 5-year mark of Josh's employment, he was to receive a 10% ownership of Autocraft at the 5-year mark. This was contingent upon Josh's decision to become a 10% owner, but once he had put in 5 years of sweat equity, if you will, he was to receive a 10% ownership stake of the company. And during Autocraft's 30b-6 deposition, the deponent was, say, hedged considerably about what this meant. He said that if Josh, quote unquote, acted right, he would be given the 10%. And if he didn't act right, he might have to buy the 10%. Be that as it may, arguments at the judgment on the pleading stage from opposing counsel, from Autocraft's attorneys, relied quite heavily on the existence of this agreement and an argument that Josh owed the company a fiduciary duty as a rank-and-file employee. The court correctly dismissed that breach of fiduciary duty and unfair trade practice claim, which is not on appeal before this court. But I note that throughout this litigation, it has been clear that Autocraft benefited from Josh Langley's employment with Autocraft. This will be relevant to the estoppel issue if after we get through the Canteen discussion. But at the 5-year mark, Josh did not receive a 10% ownership stake of the company. Josh made demand in July of 2022 for the 10% ownership stake. There was a recorded conversation that Josh recorded with Mr. Clapp, the president and sole owner of Autocraft. And during the deposition, I played this recording for Mr. Clapp, the owner of Autocraft. And Josh had said something in the recording to the effect of, "We'll figure out how you're going to do this 10%. How are you going to give me this 10%? And Mr. Clapp said, "Yeah." And really without prompting from me in the deposition, he explained what "yeah" meant. He said, "Yeah, I'm going to have to figure out how much the damn company is worth to give him the 10%. So at the deposition, he acknowledged that at this point, Josh has been there 5 years. They've complied with every other term of the agreement, and that Josh was entitled to 10%. Josh never got the 10%, which is, of course, why we're here today. So at the business court, which is how we ended up here, we were at the business court, so we had to appeal directly to this court. The trial court relied on the last line in this agreement to invalidate the entirety of the agreement. The last line says, all above is guaranteed for the next 20 years with nothing to change except at Josh Langley's discretion from the signed date below. So that nothing to change except Josh Langley's discretion is what the court relied on by saying that this agreement was completely illusory because, according to the court below, Josh could do whatever he wanted. It was an agreement to agree, if you will. Now, there are a few fundamental problems with that analysis. First, Josh testified what he meant by this provision, or what he understood this provision to mean, was that it would require both parties to consent to any change. So, for example, if Autocraft requested a change, Josh, of course, would have the discretion to say yay or nay to that change. And so, on one hand, throughout the litigation, I heard a number of arguments that the agreement is too vague, it's indefinite. And then on the other hand, though, we hear, well, clearly, though, this provision is clear on its face. It means Josh can unilaterally modify the contract. I'm not so sure that it's that clear, but even if it were that clear, that Josh could unilaterally modify the contract, that brings us into the canteen analysis.
Before we get there, can you help me? I assume, like the court has, you've looked into why we have this common law doctrine about illusory contracts. And the one thing that I didn't understand, but typically when we're dealing with the common law, I'm probably the one missing something because it's kind of hundreds of years of legal thinkers kind of slowly iterating on something. But what I couldn't figure out is why, in a case like this, if there was never any attempt by the party to use that provision to create this sort of unfair unilateral power that's what renders it illusory, why wouldn't the remedy just be that you delete out of the contract the portion that creates the illusory contract? But if the parties have indicated an intent to be bound by the rest of it, it just operates as it did in the beginning. And I mean, this case to me seems like the perfect highlight of that, because you can just imagine that language isn't in there. No one ever tried to take advantage of it in this case. So why is it that we just say, no, the contract is void from the get-go?
Well, I'm going to be somewhat arguing my friend Mr. Sutherland's position here on that. So I agree with your premise, of course. But if it's an agreement to agree, right, that is a problem, and that it's not enforceable. But the Brooks decision from this court dealt with an indefinite or an illusory agreement to purchase real estate. The parties were a bit reversed because the plaintiff was the buyer in that case and sued to get out of the contract. And the contract was indefinite in that particular case because it didn't describe the real property with particularity, which would be a requirement for the sale of real property. However, the parties had operated for 8 years, and partial payments have been made, property taxes payments have been made by the plaintiff, and the court basically said, whoa, you're stopped from denying the effect of this agreement because you have accepted the benefit of effectively owning and using the property, and those rights have been reserved for you. So we're not going to have you come in and accept the benefits for 8 years of this agreement and then come back and try to argue that it's illusory or indefinite just because it no longer suits your needs. And so there is, of course, a place you can't have an agreement to agree, but if the parties have accepted it and operated under this agreement for 5+ years at an absolute minimum, there's a factual issue here as to whether or not the doctrine of quasi-estoppel should apply.
Well, this is what I'm interested in, is before we get to whether there would be equitable doctrines that would salvage the contract, it just seems to me the thing that's odd about this principle of law is that, so it's your client that would benefit from the ability to unilaterally change the contract at any time. And so it would be removing, if we just remove that provision, it would be removing from the contract a provision that benefits your client, but that your client is perfectly happy to have removed from the contract in order to keep the contract as an enforceable one. And so it seems to me that by removing that, unless there was some evidence that without that provision, there would have been no offer acceptance consideration, meeting them, then why not say, well, there is an enforceable contract? And here it does seem the parties bargained for even just deleting that out because it was never an issue in the case. The parties bargained for the rest of what's in this contract. So I'm just trying to figure out, is what the common law says that, well, just go to equitable remedies, which I think are harder for you than just trying to say, well, can we just have a contract that doesn't include the last sentence?
It's curious. I have not, candidly, as much as I've thought about this last sentence, thought about it quite in the way that you phrased it. But I think you're right. I think Josh could say simply, with some degree of irony here, because I have this right to unilaterally modify the contract, then I'm going to strike this provision. And I think that would probably put us squarely, or a more similar situation to Canteen, where someone tried to actually modify the agreement. That, well, I'm not going to enforce this. I'm going to strike it from the agreement under Canteen. I can do that. And then separately to the next point or question that you raised was, if we can strike this and we still have a contract, the promises are divisible. And so I think we've got fair consideration here to support the rest of the agreement. And I think a perfectly appropriate remedy would be to strike this last sentence. Now, I'd feel a lot better if I had a severability provision, if someone had handed me this agreement in 2016 to review and clean up, tidy up a little bit. But here it is. And so if there's a severability provision, if we're up here still with that provision, it's on a much different basis, I think. So the Canteen case, the distinguishing feature that the court below relied on was that that Canteen, just a very brief background on Canteen, I know the court's familiar with it, but this was a credit union that had a change of terms provision in its, this court referred to as a contract of adhesion for its credit union members. The credit union actually utilized the change of terms and inserted an arbitration provision into that agreement. This court said you can have a change of terms provision provided it relates to the universe of topics that was contemplated at the time of the contract formation. And it is limited, the promisor's freedom of choice is limited by the duty of good faith and fair dealing. And in fact, this court said that an otherwise illusory contract may be remedied because a limitation on a promisor's freedom of choice may be supplied by law, the law being the duty of good faith and fair dealing. So even were this court to determine that this last sentence, if this court were to agree with the court below, that this last sentence is a problem, it renders the contract illusory, we can't strike it. The contract is still enforceable even if it is otherwise illusory under Canteen. Now,
but one thing that would be a little odd about your accepting your argument, I mean, I think I'm going to be generous to the business court, who I think doesn't want to be quite as critical of this court as I think I could be. But what the business court seemed to me was saying is, if you don't try to restrain these two contracts of adhesion, where you, and not just any contract of adhesion, but one where the reason, what's happening in the bargaining power disparity is that you have one contracting party who will contract with many thousands, maybe millions of people, and must have the identical contract with everyone, and that it's in that particular scenario. And the reason that we must have meant that is, if not, because the implied covenant of good faith and fair dealing by law is a part of every contract unless you disclaim that it's part of your contract, then we basically got rid of the illusory promise doctrine, this like long-standing common law doctrine with no discussion whatsoever of sort of the enormity of what we would be doing there. And that seems odd to me. So tell me why from that one, I understand the sentence you're pointing to, but how do we get from there to saying, forget the stuff you study in every law school classroom, it doesn't exist in North Carolina anymore?
So I would counter this by saying it's not just contract adhesions where these issues come up. So I was an in-house counsel for 5 very long years and dealt with software service agreements somewhat routinely, and they drive a pretty hard bargain. And they often hyperlink their terms. We have a huge software provider here in Cary. And they often hyperlink their terms, and it is not uncommon to say, these are our terms as of April 15th, 2025, but they're subject to change. Now, as the buyer's lawyer, would I try to push back on that? Of course. Sometimes I was successful, sometimes I wasn't, depending on the needs of the client. But I think these provisions are more pronounced then it may first appear that it's just a contract of adhesion and they need to have uniformity and that sort of thing. Because of this exists in the business-to-business world, and in fact exists at least according to the business court in this case, based on that sentence, that this change of term provision existed, and I still question the underlying premise that sentence would actually, as written, allow Mr. Langley, to unilaterally amend the agreement, or if in the context of the agreement, it means that Josh has to consent to it, which is what he testified to as to what that meant. And so that's the Canteen decision, in some respects, I think, only highlights why the trial court erred below, because here we had two parties that at a minimum met each other on equal footing, although one could argue that the prospective employer is on better footing than the prospective employee to negotiate a contract. But not an argument we need to go down, because the parties had full opportunity to review this agreement, executed the agreement, and then operated under the agreement. In that recorded conversation, for example, this is after Josh had made demand of Mr. Clapp to get a 10% ownership stake in Autocraft. In the midst of that recorded conversation, Mr. Clapp was bemoaning the fact that he didn't require Josh to punch a time clock in the agreement. So even as the parties are just contesting the nature of their relationship and things are breaking down, Mr. Clapp is still acknowledging that the agreement governs their relationship. And so what Mr. Clapp, for the moment at least, has persuaded the business court is that he was allowed to take the benefits of 5 years of Mr. Langley's employment, but not have to take all of the downside, if you will. He certainly paid Mr. Langley, I'm not disputing that, but he got the benefit for 5 years. And as for the benefit, you need not take my word for it. The counterclaim that was filed in this case and the oral arguments regarding that counterclaim from defendants are replete with references to just how important Mr. Langley was to this company. Not long after Mr. Langley started, Mr. Clapp had sent a profanity-laden email to Roush Racing, which at the time represented 50 or 60% of Autocraft's business. And Mr. Langley went from just being a programmer to now the head sales guy of the company and generated revenue. Mr. Clapp testified to this, generated revenue for the employees in the shop and kept the business afloat. So Autocraft clearly benefited from Mr. Langley's employment because of this agreement. So under the Whitaker case and its progeny, once a party accepts an instrument, this agreement that Autocraft clearly has, and accepts a benefit under it, which Autocraft, I think it's undisputed, did. Even Mr. Clapp acknowledged that Autocraft received at least some benefit. At a very minimum, there is an estoppel issue, a quasi-estoppel issue that I think, again, at a minimum needs to be resolved by a jury. I think I have a pretty fair argument to make as a matter of law that Autocraft should be estopped, but don't need to get that far to prevail today. At a minimum, though, a jury needs to make a decision as to whether or not Autocraft accepted this agreement and whether or not it benefited under this agreement. So that bypasses the Canteen discussion. But either basis stands as a reason to reverse the court below. Related to the quasi-estoppel issue is the mend the hold doctrine, which is referenced in Whitaker again. And the mend the hold doctrine is akin to judicial estoppel, but it is a little different in that it applies to legal positions taken. And as I mentioned, after this lawsuit was filed, there was a counterclaim filed against Mr. Langley and the company Mr. Langley formed and was working at, LBM Metalworks. The court dismissed those claims, but the court alleged unfair trade practice, the Autocraft alleged breach of fiduciary duty and unfair trade practices. Now, the pleading is interesting because the pleading does not explicitly rely on the agreement. But at hearing, I think recognizing the general rule that an employee does not owe a fiduciary duty to a company, absent that employee being an officer of a company, which Mr. Langley wasn't, and with some degree of irony, perhaps he might have been had they given him the 10%, but that, of course, is not where we found ourselves. So the mend the hold doctrine, I saw in the responsive brief, they said, well, they just relied on one line. I did reference one line in our brief for the issue of space, but this argument below, Mr. Sutherland did not make it, but this argument below is replete with reliance on the existence of the agreement. Page 17 of the hearing transcript from the judgment on the pleadings includes the following. So now let's take a step back. Is he just an employee? The answer is clearly no. And in none of the cases cited do we have an individual that has a right to buy the entire company. And that's what's going on here. If you accept this document as accurate, he would have been given the right to buy the entire company. That's not just an employee. So it's a unique aspect of this case. It goes on from there. And it's relied heavily on. They took the position when it was expedient for them to take the position that the agreement created a fiduciary obligation. But now they want to hold the agreement back and say, no, that agreement isn't enforceable. And in fact, not only is it not enforceable, we, Autocraft, didn't even execute it. Keith Clapp executed it in his individual capacity. So at one point in this proceeding, this agreement was so critically important that Josh violated the Chapter 75 based on his conduct. It was that important that he committed an unfair trade practice. But now that it's not as convenient, the agreement isn't valid. In fact, Autocraft didn't even sign it. So I think at a minimum, the mend the hold doctrine is another issue that should have received some analysis. I note that the estoppel argument and the mend the hold argument that were raised below were not addressed at all in the business court's decision. It's just simply not addressed. And at a minimum, there are facts which would support the submission of those issues, or at least the quasi-estoppel issue, to the jury. The mend the hold issue is not as clear to me if that's a legal determination from the court like judicial estoppel. The case law is just not as developed on that. I think it's probably a more fair, in all candor, application that it'd be treated more like judicial estoppel given some of the overlaps between mend the hold and judicial estoppel. Next.
So just for clarity, is your position that the business court didn't address your argument, or that the court must have, by necessity, must have rejected your argument and just didn't explain why? Which typically the business court, unlike ordinary superior court, they do explain. But what do you think?
I'm speculating, of course. I think they decided not to address it. So just back, I'm a former law clerk myself at the Court of Appeals. And so my thought here on this when I read the decision was, we got this line, this is how we're going to go with it, and it's going to be upheld because it's illusory and I don't need to deal with anything else. That's the quickest way to move this along. It's total speculation. I'm not suggesting there was anything untoward done by any means. But the problem with that analysis, that limited analysis, is just if we live in a world where this is an illusory contract, let's just assume that. That doesn't end the analysis because the equitable doctrines come up. And at a minimum, they need to be dealt with. And they just weren't dealt with below for whatever reason. There were some other issues raised below that, like whether or not Mr. Clapp had the capacity to contract as a matter of law, that appears to have been abandoned. I will just note that it's abandoned on one hand, but referenced several times throughout the brief. They don't make the legal argument. Just to be very clear, there was no medical testimony that Clapp was incompetent to testify, or excuse me, to sign the agreement. That is universally a jury question. And even if he was not competent to sign the agreement when he did, there is always the issue of ratification. Clapp acknowledged that at various points he was sober while operating Autocraft, and of course Autocraft can ratify a contract that was otherwise entered under the influence. So that argument was not also addressed by the Superior Court, and I don't find terribly persuasive, but I did want to at least acknowledge it because it is, those facts are referenced throughout defendant's brief. Lastly, there's an issue of divisibility. Again, this was raised in part below. I addressed it head on in a reply brief because I felt that it was just, we were nipping around the edges of it, so I wanted to get it out there and have a discussion with the business court about it. And this is not an issue that the business court relied on, but of course, at summary judgment, this court could. The contract, as noted, contemplates that Mr. Langley will get 10% for sweat equity after 5 years. And then later it says, owner finance the other 90% over the following 5 to 10 years. Defendants, Autocraft argued that that is not an enforceable promise, the other 90%. And obviously, Mr. Langley never got the 10% to enter into any sort of purchase agreement for the other 90%. But the question then is, if the 90% provision is not enforceable, is the 10% provision supported by separate consideration? This seems fairly clear that the 10% is acquired upon sweat equity. The 90%, if we assume that it's not enforceable, contemplated owner financing, which means cash. That's not a sweat equity provision. So that means that those promises, 10% versus 90%, are supported by separate consideration. Sweat equity versus cash. That renders a contract divisible, and so that the 10% provision may be enforced. Although a bit unusual perhaps to leave some time on the clock, unless the court has further questions for me, I will reserve the balance of my time for my rebuttal.
Thank you, counsel. We'll hear from the appellee.
Chief Justice Newby and members of the court, good morning. Jeff Sutherland here from Greensboro with my law partner, Richard Andrews. As Mr. Rust alluded to, and as the record reflects, this is a case about a one-page document signed in the parking lot of a Hooters, written by Mr. Langley. That is where some of the excitement of this case ends. Frankly, the balance of this case and affirming Judge Earp's summary judgment ruling simply requires this court to follow decades, if not a century or more, of established contract law related to illusory agreements, indefinite agreements, the failure of Mr. Langley to exercise an option as required by this document, and then failing all of that, to simply reject the equitable arguments made by Mr. Langley below. Let me speak to what I think are actually undisputed facts that are dispositive. It is undisputed that Mr. Langley was the drafter of this document. That is not disputed. It is undisputed that Mr. Langley did not attempt to purchase or otherwise acquire or receive any part of Autocraft until July of 2022. Some 5.5 years after he started work. And it's undisputed that Mr. Langley has never attempted or indicated a willingness or a readiness to acquire the other 90% of Autocraft. In fact, in Mr. Langley's deposition, and this is undisputed, Mr. Langley specifically testified, we'll figure out something on the 90%. We'll make a determination later as to how that will go down. That is the quintessential agreement to agree on the 90%. And the 90% is directly related to the 10%. How do we know that? Well, as a matter of writing, it's all one bullet point. Mr. Langley's ownership interest is all one bullet point, the second black bullet point in this document, and 3 sub-bullet points. And specifically, the 90% speaks to the fact that it is the other 90%, which necessarily means that Mr. Langley's got to acquire the 10%. Another undisputed fact is that the words on the page say what the words on the page say. Specifically, and as relied upon by Judge Earp, nothing in the agreement could change except at Mr. Langley's discretion. That is the paradigm of a unilateral, unfettered modification provision that North Carolina law does not allow to be enforced. All of these facts, everything that I just relayed, is in the record, was in front of Judge Earp, and is undisputed. As to the first argument related to the contract being illusory, the Canteen decision doesn't, to our reading, undo decades of law. It doesn't undo the principle that an unfettered right to modify an agreement could nonetheless be saved down the road. The Canteen case was focused on a consumer context, as this court and Judge Earp observed, where there are significant policy reasons in play, not the least of which is uniformity of contracts, policies in favor of arbitration, the wildly impractical scenario of trying to go and get signatures and that type of thing from millions of consumers. None of those are in play here. In fact, I would note, and from our standpoint, the seventh footnote in the majority decision talks about the fact that employment contracts are different, strongly suggesting that the analysis upholding the change in terms, arbitration-oriented provision in Canteen wouldn't apply to what we have here, which, as my colleague has indicated, is principally an employment-related agreement. And so the Canteen case not only has those distinctions in play from a policy and a legal standpoint, but in that case, there was actually an enforceable agreement, as this course talked about. The threshold determination was that there was an enforceable contract. That's not the case here. Related to Canteen, the argument that we have effectively heard from the appellant is you can have an agreement with a change in terms provision, and then you can come back after the fact, some years later, to do an analysis as to whether or not that provision may or may not be enforceable based upon whether it may or may not have been invoked. And in this case, based upon testimony from Mr. Langley, that's completely at odds with what this provision says, which is that he had the sole authority. Justice Dietz, to your question, we don't believe that North Carolina law would allow for the excision of this modification provision. That would require the court to rewrite the bargain that was structured on this page. And simply, we don't believe that there would be support for that. Related to this issue, the fundamental problem is that there is no obligation on the part of Mr. Langley from the time this contract is signed. No obligation at all. He could change everything.
Before you get too far off Canteen, excuse me, I understand the arguments you're making about the different context, but the language that was at issue in Canteen said, quote, defendant may change the terms of this agreement, unquote. How is that different from the language here?
Well, as I recall the language in Canteen, there were also limitations with respect to what would be supplied by law.
So are you saying we would have held that the implied covenant of good faith and fair dealing did not apply if that language, except as prohibited by applicable law, hadn't been there?
I think that's an assumption that we would make and that we would think the court could have concluded that, yes. We would also note, while we're talking about the language, Justice Allen, in Canteen.
So just to be clear, in your version or your take on the law, the implied covenant doesn't apply unless there's a provision in the contract that says, except as otherwise provided by law.
Based upon Canteen, that is our interpretation of how the implied covenant of good faith and fair dealing would apply.
Does the holding in Canteen turn on the presence of that language?
I don't believe it turns on the presence of that language. I believe it turns on a number of other issues related to the posture and the policy and the framework. And we would also argue, as we're talking about the language of the provision in Canteen as compared to what we have here, Canteen provided that there would be notice and an opportunity to opt out. We don't have any of that here. In other words,
Well, I think in Canteen, they gave people the opportunity to opt out, but I'm not sure that the change of terms provision guaranteed that right.
I believe that the contract itself provided for a notice and an opportunity to opt out of the change in terms and the other provisions. And in this case, we don't have any of that. We have no opportunity for Mr. Clapp or Autocraft or anyone, whoever the parties are, to either be told about the fact that there's a modification, much less to opt out. And frankly, unlike in Canteen, and Judge Earp touched on this, and this court touched on this, in Canteen, where consumers have the opportunity to take their banking business somewhere else, there are a host of other opportunities. You don't have that here.
So I'm going to probably confuse everybody, including myself, with what I'm about to say. But it seems there's a problem with saying, well, the implied covenant of good faith and fair dealing applies in Canteen because there's this provision that says, except as prohibited by applicable law. Well, that provision assumes that there's already something that's prohibited by law, right?
Right.
And so doesn't that mean that the implied covenant of good faith and fair dealing has to already apply?
I think the context is important. The way that we read Canteen. And
I'm just asking about as a matter of logic, or if my logic is wrong, help me understand.
I understand the court's logic to be, if we say supplied by law, that necessarily includes a covenant of good faith and fair dealing that is supplied by law. Is that?
Say that one more time, sorry.
I understand Your Honor's statement to be, is the supplied by law language necessary if the implied covenant of good faith and fair dealing is necessarily supplied?
Yeah, I mean, a simpler way to put it is, I just don't think Canteen stands for the proposition that the implied covenant of good faith and fair dealing only applies to contracts where there's this language except as prohibited by applicable law. Am I wrong about that?
I don't believe, to Your Honor's comment a minute ago, that the Canteen decision rests upon the fact that that language.
Okay, so now I'm back to where I was at the beginning, which is setting that aside because you've just said it doesn't turn on that. The decision doesn't turn on that. What we have here is a statement in the contract. Defendant may change the terms of this agreement. And I'm struggling with how that is any different in a material way from the provision at issue here.
It is materially different because of the context in which this agreement being the one that's before the court today, originated. It's not in the consumer context. You don't have the policies in favor of arbitration. You don't have, frankly, an existing contract at all in this case. And
so we're going to, now this is a tendentious way to put it, but we're going to read in the implied covenant of good faith and fair dealing to save the contract for the credit union, big finance if you want to put it that way. But when it's a non-lawyer drafting a contract, we're not going to give that person the benefit of the implied covenant.
I think that I would frame that issue differently. And the way I would frame that issue is...
I would think you would.
Yes.
I would think you would.
In Canteen, based on those specific circumstances, right, as noted by all of the cases cited, the dissent makes a distinction there. Based upon the specific circumstances in Canteen, based upon the heavily regulated consumer and banking industry, based upon the impracticability, based upon the policy in favor of arbitration, this court said, in that circumstance, a change in terms provision is not rendered illusory because we have the covenant of good faith and fair dealing to rely upon, which is to say, Canteen is a specific decision focused on the specific facts of that case.
See, I don't see anywhere in Canteen where, I grant you, that is the background of Canteen, of course, but I don't see anywhere in the holding where all those things are tied together in the way you just said.
Well, and that is why I believe that if the court is inclined to address Canteen, there's an opportunity to clarify that what was intended was not to unsettle decades and restatement of contracts-oriented principles that illusory contracts can be otherwise saved down the road after the fact through invocation of the covenant of good faith and fair dealing, and with reference to an analysis of was a provision invoked or not. And in fact, as a practical matter, the purpose of contracts, as this court knows, is reliability, predictability. A scenario where the only way you can evaluate whether or not a change in term provision is valid is to come back years later and see, did someone invoke it? Or more generally, to say whether, more specifically rather, did Mr. Langley attempt to modify the agreement? Whether he did or did not, he had the right to, and he was the only one that had the right to. And so we think the Canteen decision is actually focused on the specific facts there. We think it's important in the footnote, in the majority decisions, footnote 7, where there's a distinction that's drawn between some of the cases that are pointed to that specifically distinguishes employment contracts like what we have here, that makes implicit, if not explicit, what this court can now make explicit, which is that Canteen is focused on the facts that were in front of this court in Canteen with a significant number of policy considerations that were not in play here.
Can I just ask you about footnote 7? Because it seems to me the distinction there is not employment contracts versus other types of contracts, but the fact that in those other cases, the contracts initially contained arbitration agreements, and this one didn't. And it's the initial presence of an arbitration agreement that makes those cases different from Canteen.
Sure, and the language that we're pointing to, Justice Earls, is the next to last sentence in footnote 7, which speaks to all but 4 of these cases concern employment contracts. And we reread that language, and the way we had interpreted that was that the court is drawing a distinction between an employment contract, where you have this one-on-one scenario without notice, without the ability to opt out, the other concerns that would be in play in Canteen, that employment contracts would be treated differently.
Right, but it says employment contracts which initially contained arbitration agreements. So it isn't the issue here that they contained arbitration agreements, and in Canteen it didn't initially contain arbitration.
Well, and I understand Your Honor's point. The way we interpreted footnote 7 was that the court was drawing a distinction. I think that to the extent the court was not drawing a distinction in footnote 7, we think the distinction is nonetheless critical. And that's because in this scenario, unlike in Canteen, where there's an opportunity to go to the marketplace, to take your business elsewhere, you don't have that here.
But certainly there are other people who could have been employed to do this work.
There are other people who could potentially have been employed. The conflict and the problem is that Mr. Langley was the only person with the ability to modify this contract. And for example, had Mr. Langley come back and said, I'm going to modify this contract to say I get my interest in 3 years, or I'm going to modify it to say I get the 90%. I just get it. Right? Are we going to then be at a point where we're coming down after the fact and having to evaluate, well, wait a minute, I know what they wrote. I know Mr. Langley is not otherwise obligated, but that 90%, maybe that's within the universe, or 4 years, that's within the universe. We don't see a scenario where that's workable or consistent with the principle that you have a contract, it says what it says, and in this scenario, Mr. Langley wrote that he is the only one who could change it. And there is not a North Carolina case that we're aware of where that sort of unfettered, unchecked discretion is enforceable.
But here's another thing I'm struggling with. If applying the implied covenant of good faith and fair dealing in Canteen to that very broad language that I read to you in Canteen, if the implied covenant can render that non-illusory, why can't it do the same thing for this language here? In other words, is the language in Canteen illusory? We said no because we take the implied covenant and apply it to that. Why can't we do that here?
You can't do it here, independent of the indefiniteness and the other arguments we made about the contract. You can't do it here because there's simply no mutuality of obligation at all. There is no obligation on the part of Mr. Langley to do anything based upon the way.
So your argument then is tied on the illusoriness of the contract change provision is tied to what you see as the other defects in the agreement.
I think they are related. I don't think they're dependent. The court could conclude this is illusory because Mr. Langley is the only one who can modify it. The court could conclude that based upon Philip Morris case and the other cases cited in our brief that go back to the early 2000s, 1900s, into the 1800s, that a unilateral, unfettered right to modify a contract is unenforceable. That's all this court has to do to affirm Judge Irvin.
So your argument seems to me that one way of viewing it is that you're saying, well, we took what really would have been in any other context an illusory promise in Canteen, and because it affects a lot of people, we said, well, it's not illusory. But here, no need to do that because it doesn't have the far-reaching impacts of the kinds of agreements that issue Canteen.
Our argument is different than that. Our argument is that the court's rationale in Canteen, hinging upon the fact that there's an enforceable agreement, the fact that as a practical matter, it's impossible for a bank to go out in that scenario and notify millions of people. The fact that there are other opportunities for them to go and take their business elsewhere. And the fact that there are restrictions that were available. There were ways to limit the discretion. In that case, there are, and Judge Earp touched on this at the hearing in the transcript, there are specific restrictions about what you can and can't do in the financial space as it relates to consumers. And then you take all of that context, and then you have a specific provision that says it's going to have limitations supplied by law. And this court, it appears, was able to say, in that specific context, on those facts, we were able to determine that this is not illusory because we can imply the covenant of good faith and fair dealing on those facts. We don't believe that, and this court stands in a position to tell us otherwise, we don't believe that what the court intended was to unsettle the decades of law about illusory contracts, which is very clearly stated to be an unfettered, unilateral right to modify, is not enforceable. And to replace that with the argument that's being suggested here by the appellant with the rule that requires an after-the-fact analysis on what's in good faith, what's not in good faith, instead of simply saying the words that were chosen in this case, consistent with North Carolina law.
So, like you, I didn't participate in Canteen, so I feel like I'm coming at this from the same perspective you are, and it seems to me that the easiest way to make Canteen make sense without bumping into the issues that Justice Allen has been asking about would be to say, well, what Canteen obviously was doing is recognizing that there's this type of contract, these take it or leave it contracts of adhesion that involve very large companies and huge numbers of consumers. This is critical to sort of the economy of our nation to be able to have these companies be able to do these transactions with these consumers. So, and it would bump into this old common law rule that just doesn't work with how we amend these contracts today, which is you just get the notice, or, you know, we heard earlier the reference to sort of the end user license agreement where it just, you know, click here and you're accepting all this. And the idea was you can do this because Congress or state legislatures, if they wanted to, can come in and we would expect them to regulate these kinds of businesses so they could put restrictions, say you can't change these terms in your contracts with consumers. We don't expect Congress or state legislatures to start tinkering with a contract with a guy that's going to be working and maybe being a part owner in a machine shop. And so common law is what's going to govern that contract. That seems to me the best argument, but what I'm struggling with is none of that is in Canteen. So it seems like if what Canteen means is what you say it means, this case needs to sort of rewrite it, don't we? Because lots of more lawyers in the future are going to be making the same arguments you heard from Justice Allen.
I think that we're generally aligned with what you're saying. I think that this is an opportunity for this court to clarify what was intended by Canteen, which is, from our standpoint, as simple as Canteen should not be read to unsettle the long settled principle about what constitutes an illusory contract. It's based upon the facts that are there. And again, we would come back to Canteen. There's a specific provision that allowed for notice and opting out. That's an important distinction. There is no notice or opting out, nor practically could there be in this type of scenario.
Sorry to interrupt you, but this is where I'm struggling with your argument, because I think Justice Allen is right, is that the power dynamic here, though, is completely changed in favor of your client, who's the one trying to get out of the contract. I mean, the problem with like the credit union contract is you have no bargaining power whatsoever as the customer. But here, the answer is that your client can just look at that final sentence and slide that piece of paper back and say, no thanks, come up with a better offer. And you've got a tremendous amount of bargaining power. So it seems odd that we would use that theory as the reason that there's a problem here. Well, because you could renegotiate I can definitely see the parties sitting in that Hooters and saying, hold on a minute, I don't want the 24-inch laptops. We're going to give you, two 17-inch laptops. Or we're going to give you, you only get 3% bonus at Christmas. Or what? You see what I'm saying? Like, it seems completely different than these contracts of adhesion.
I think the point is the provision as it's written would allow Mr. Langley to simply change it, period. And if we're talking about policy and talking about practice, a provision where you can change something without notice, without any opportunity for Mr. Clapp or Autocraft to say, well, wait a minute, we'd like to come up with a different deal, is more offensive as a practical matter than a provision where you at least have to give them those opportunities. And I understand Your Honor's point about the freedom of choice and the market dynamics that are in play. But again, we think if the court is inclined, it can simply clarify Canteen to be specific that it was focused on those facts, that legal framework, and that scenario to avoid this argument before and to avoid having these issues come back before this court.
So suppose we think you're right about that. We have this problem then that seems to be just staring all of us in the face, which is that if Langley had shown up to work and was not getting some of the other things that are listed in this contract as the terms of the deal, you could definitely see saying, wait a minute, we have a deal, I'm backing out. And the fact that he got everything else that's listed in this contract certainly creates, it seems to me, something that falls in that sort of core of what quasi-estoppel is meant to be, which is that, okay, it turned out there wasn't a contract, but the parties were acting as if there was one, and so certain expectations are enough for the law to enforce. And are you saying we should just rule on this now as a matter of law? Is this something that got overlooked? What's your position on what's going on with those claims, which seem pretty legitimate to me?
On the quasi-estoppel piece, we think the quasi-estoppel analysis is actually more simple. As to Mr. Clapp, and this is critical, and it's determinative, there was not an argument in front of Judge Earp that Mr. Clapp was stopped from doing anything. In fact, the argument we even heard a few minutes ago was Autocraft. The briefing below and the argument below focused on an estoppel theory as to Autocraft. Autocraft doesn't own the shares. Autocraft doesn't own the stock. Mr. Clapp does. So any estoppel argument as to Mr. Clapp would fail. We also made the argument below on estoppel that Autocraft is not a party, and that's based upon Mr. Langley's testimony. But more pointedly to estoppel, the quasi-estoppel case that's relied upon by the appellant is the Brooks case. That was a case where this court noted estoppel was appropriate based on the, quote, peculiar facts of that case, which involved an individual using 25 acres of land for 8 or 9 years, paying for it for 8 or 9 years, and then getting to year 9 and saying, I want my money back. And the court said, well, hold on. That conveyance, that contract fails for indefiniteness. And we're going to have to use estoppel because we can't give back the ability of the defendant in that case, so a completely different posture, to get the land back. That in Brooks, you had a reverse posture. And I would note, quasi-estoppel is based on avoiding a party benefiting from inconsistent positions. There was an argument earlier that our clients had made an argument under this contract. That's simply incorrect.
But isn't the point, there really are fact questions here. Because number one, there is a fact dispute about whether Langley would have continued to work just for the salary and other general employment benefits, or whether the amount of effort they put into that was based on his understanding that he would be receiving this equity stake in the company. That's certainly his position, it seems to me, in the record. And even on some of the other things, like the question about authority when signing the contract, who actually entered into this contract, that seems to me to be the fact question, because there's a dispute about what was going on there. So, and isn't that why we really can't rule on these questions, that the business court needs to either send it to the jury or make a determination that there's no genuine issue material fact?
We think the court can rule on clap for the reason that I mentioned. We think the Brooks case is clearly distinguishable based on the peculiar facts there. We also think there's a fundamental problem on estoppel, is who are you estopping and what are you estopping them from doing? This contract is so devoid as to terms, as to the 90%. How's it going to be paid for? Who's going to pay for it, et cetera. And so the concept of estoppel, and this is what happens in Brooks, the concept of estoppel is there was a specific thing that could be estopped. The court said, you know what, this is indefinite, the real estate description, but we've now made it definite because we have a survey. The indefiniteness had been alleviated. And so you have the peculiar facts in Brooks, you have the alleviation of the indefiniteness, you have the different posture. And frankly, there's no fact issue about the posture differential. And so we think the court can rule on estoppel and the other issues. So
Thank you, counsel.
appreciate your time.
Rebuttal.
I think I think what we've heard here today is essentially an argument that is Canteen limited to its facts. That is, I mean, I appreciate that Mr. Sutherland didn't want to quite go there. I wouldn't want to either. But that's the argument, essentially. Is Canteen limited to its facts? I'd say the answer is no. The court said what it said. There's a duty implied by law of good faith and fair dealing. And the court contemplated we were going to look at whether or not an amendment to an agreement where a party has a unilateral right to do so complies or comports with the obligation of good faith and fair dealing. And so that is what was contemplated. And the Canteen court, of course, didn't pull this out of the sky. They relied on other cases and precedent to reach that decision. And so it is not a completely novel concept by any stretch of the imagination. And importantly, in this case, to lose sight of this fact, it was never actually utilized. The provision was never used. And the argument the agreement was drafted by Langley, therefore must be construed against him. Well, would it be construing the agreement against Josh Langley to find that he had unfettered discretion? Or would you construe the agreement against Langley so that it limits his ability and his discretion? I would think if you were to construe an agreement against a drafter, you would construe it to limit his discretion. It also helps that that's exactly how Mr. Langley testified, that he understood what that provision meant. Another piece of analysis the court didn't address. So I think at the end of the day here, the defendants would like this court to determine that Canteen is limited to its facts. Josh Langley is asking you to apply Canteen as it's written. If Mr. Langley's argument on Canteen is not persuasive, that doesn't end the analysis for Mr. Langley and his ability to enforce this agreement because of the estoppel issues that are quite rampant in this case. At a fundamental level, Autocraft and or CLAP, and I did make reference to both in the briefs below, but generally refer to them as one entity for ease, benefited greatly from Langley's employment and now seek to avoid the burden of the agreement that it executed. This court should not permit that. For those reasons, this court should reverse the business court's grant of summary judgment and remand for a trial. Thank you.